Hi, I'm Tom Bradford. In this live stream, I'm going to explain the changes that you ought to know about to the immigration rules in the most recent statement of changes. And this includes Appendix W and the changes to the startup and innovator visa routes. So let's make a start. So the first point here as relevant is in relation to the contact points. So this part of the immigration rules provides for how often you need to be in contact with your endorsing body once your innovator visa or startup visa is granted. And what it states, which I think is quite helpful, just for clarification, is that you've got to maintain contact with your endorsing body as required as a minimum after 6 months and 12 months from the date the application was granted. So 6 and 12 months from the date the application was granted, and that's the new bit because that wasn't clear previously. So I think where this is particularly relevant I'll speak in a moment about when these rules are going to be implemented from June, because they only apply to new applications. But if your innovator or startup visa application is granted towards in the second part of the year, and if the corona crisis is going on, you're not able for any reason to actually come in to the UK, then you'll still be assessed in terms of that contact point from 6 or 12 months from the point the application is granted, whether or not you've actually been able to come into the UK, or if you've been held up abroad, which may be possible if there's a second coronavirus wave in the winter. We certainly hope not. And you must show reasonable progress against the business plan. And this is an interesting point. At these contact points, the applicant must either show reasonable progress as assessed by their endorsing body against the business plan assessed in their endorsement, or show that they are pursuing a business venture which the endorsing body is satisfied meets the requirements in paragraph W5.2 below. In other words, innovation, viability, scalability. So in other words, you can be pursuing a new business venture other than the one for which you're endorsed. That's clearly very important. So you can switch businesses if you like while you're in the UK. But what you have to do is obviously plan this strategically if you were to do something like that. So if you're on and this provision is in there in relation to both startup and innovator visas now. So you could, let's say if you're beginning on a startup visa and you begin with one business and then you decide to change the business, let's say perhaps it's something to do with the corona crisis, if you're doing something in relation to travel or retail and decide to change the business, then you've still got to be supported by your endorsing body. But when you come to apply for the innovator visa, you'll be applying under the new business provisions, and you'll be assessed in relation to the new business provisions. So that needs to be planned out carefully. So that's the second point. Again, that hadn't been there in the previous rules. Now, the next provision here is in relation to viability. Now, I've done videos on what business viability means in this context, but it says here the applicant's business plan is realistic and achievable based on the applicant's available resources. The applicant has or is actively developing the necessary skills, knowledge, experience and market awareness to successfully run the business. Now the new bit here is based on the applicant's available resources. So the endorsing body has got to assess whether what you're planning to do is realistic and achievable based on your available resources. Now your available resources could include support from third parties in my view, but they're still looking at your resources. Now resources are going to at the very least include, although they're not necessarily limited to money, and this is within the startup provisions now. So although there's no minimum investment, there's still got to be an assessment of what it is that you're saying you're going to be doing in the UK, and what available resources you have to achieve that. The next amendment is here. It states that I've just underlined it here in red for you, that the applicant must be either a sole founder of the business or an instrumental member of the founding team. More than one applicant can be endorsed for the same business as long as each applicant is a founding member. The applicant must be relying on their own business plan, and they must have generated the ideas in the plan or made a significant contribution to those ideas, and must be responsible for executing the plan. So the point here is that you've got to be an instrumental member of the founding team. It had been already present in the earlier rules that more than one applicant could apply, but I think this just emphasizes that you've got to be core to the delivery of the business. So it's got to be your own idea, and you've got to be delivering it. You couldn't simply be piggybacking off someone else's idea, or let's say just purchasing an already trading business where you were not a founder originally. And these rules take effect from the 4th of June. So if your application, if you had a certificate of sponsorship before then it would be decided under the earlier rules before this was implemented. Now, another interesting point here under viability is that you've got to show you have the necessary skills, knowledge, or experience and market awareness to successfully run the business. So market awareness is important, and it's something which you might be tested on. How well do you know your particular market? And this is another interesting development. So it says the business may have already started trading in the UK, but the applicant must be either the sole founder of the business or an instrumental member of the founding team. As we covered in the previous provision, it says more than one applicant can be endorsed for the same business. But previously it had not been obvious in the rules by any means that you could start trading in the UK. So the provision now is that you can apply in respect of a trading business, a business that's already trading, but you need to have founded that business yourself under the new rules. So in conclusion, then I think there's nothing which is particularly adverse to applicants. Or I don't think the threshold is particularly made higher. These are largely clarificatory amendments. To the extent there is anything novel in there, it's only applicable from the 4th of June. I think if there was anything that was arguably new, it would be this. I suppose the point that the time runs from the 6-month and 12-month runs from the date of the application. This point about the assessment of your own resources, the requirement that you be an instrumental member of the founding team, that you're responsible for executing your business plan, that you've got to have market awareness, and that your business may have already started trading. So I hope that that's a helpful review of the startup visa rules. Now, under the statement of changes, there are also other amendments to the sole representative route, which I'm going to review in the next video, and also there's amendments to the exceptional talent pathways as well, which I will also review in a live stream later this week. Thank you so much for listening, and stay well. I'll say bye for now.